What to do if you find yourself in the probate process. While we all want to avoid probate as much as possible, there is a way to get through it, and we can help you to do it as effectively as we possibly can. We all understand that courts are overworked, overburdened, too many litigants, too many people trying to get through the probate process, and it creates turmoil. It creates a lot of angst and heartache for people. But we can get you through that process. What it looks like starts, like most legal matters, with a fact investigation. Once retained, we'll sit down with you, either in person or over a Zoom meeting or a telephone call, and find out as much as we can about your loved one who passed away. What did they own? Who were they related to? Did they have children? Who were their children? Did their children predecease them? Who are their grandchildren? And we need to assemble all of this information. We need to assemble their names and addresses and where they lived, and if anyone died, when they died. We need to collect a death certificate from your loved one's passing. We need to get as much information as we possibly can. Did they have a will? Do we have the original will? Where is the original will? We take that information and we make a determination of what type of probate are we gonna have. Is it gonna be an administration? Is it gonna be an informal probate? Or is it gonna be a formal probate? Now, if it involves property, that the decedent or your loved one owned a house, in most circumstances, we're gonna have to go through the formal probate process. If there's no will, or the will isn't adequate, it doesn't contain what's called the power of sale, we're gonna have to go through another step called obtaining a license to sell. Well, the probate process starts with a series of documents that we draft that set forth who the personal representative is gonna be. They will lay out who potential personal representatives could be. We'll determine who has priority of appointment. Hopefully that's the person that we're working with. But if it's not, we can still help them. And we'll bring forth the necessary probate action. What will happen next is we'll file with the court. In most instances, generally speaking, we'll receive a citation. We'll have to publish. That allows the world to know that your loved one passed away, the decedent passed away, and that creditors can make a claim. In Massachusetts, creditors have 1 year to assert a claim against an estate. After that 1 year, the rights are extinguished. And then after the citation is issued, the publishing is done, the return of service is returned with a tear sheet, which is proof of publication. Eventually, the court will issue letters of authority to proclaim or let the world know who the personal representative is. These letters of authority are going to allow that personal representative to act on behalf of the estate. At the same time, we'll obtain an EIN, an employee identification number, which is kind of like a social security number for the estate. And with that EIN and the letters of authority, we'll help the personal representative open up a bank account, an estate account. All the money from the estate will be compiled in that account. The personal representative at that point will have the ability to list the property for sale. Mind you, up until this point, the personal representative didn't have the right to sell the property. The heirs, or the personal representative, or someone, needs to continue to maintain that property. Need to make sure there's heat on, the property's winterized, bills are being paid, furnace is full, accounts, taxes, everything's still running to ensure and protect those assets. Once the person's appointed personal representative, at that point they have access to money. But before that they didn't. It's another one of the downfalls of probate. Over the next year or over the year after the decedent dies, it's kind of a lull period where assets are held in the estate account. Creditors have the right to assert a claim. The house can be sold, assuming there's a power of sale in the will, or there is a will. If not, you have to go down the process of obtaining what's called a license to sell. This is a little bit of a convoluted process because you can't even really start it until you have a seller, you have a signed purchase and sale agreement, and you have a closing date. Now, the problem is you could have a closing date in 15, 30, 45 days, and the question is the court gonna be able to issue the license to sell within that time period? So now you run into the equation or the problem of, I have a buyer who's ready, willing, and able to buy, but I can't sell to them because I can't get the license to sell back from the court. I can't tell you how many deals I've seen fall apart because we're still waiting on a license to sell from the court, which is overworked, underpaid, too many litigants, and all the horror stories you've heard. Well, if all goes well, we get the license to sell and the property can be sold. If within that year waiting period, those assets go into the estate funds. And after that year, assuming no creditors made a claim, you can then start to distribute the assets to the heirs. Assuming all the heirs are alive and they're clearly defined and none of them predeceased the decedent, or none of them have passed away during the probate process. When that happens, it starts the process over. The person who passed away, their estate needs to be probated, and their share, assuming the will gives their share, or if there's no will, it definitely has to happen, their share would go to their heirs. So now you have a probate on top of another probate, which best case scenario we're handling, but sometimes another attorney's handling, so we're coordinating with another law firm and the court. If it sounds like there's a lot of coordination, there is. And all of this takes a lot of time and a lot of money and a lot of frustration from our clients. And oftentimes where we take the brunt of that frustration because we're waiting on the court. But eventually we always get through. It could take anywhere from 14 months to 2-3 years, or even longer, depending on the facts. Does somebody come out and contest the will? That just blew up the probate by contesting the will. Do creditors come out and contest or stake a claim on the decedent's funds? Again, blows up the probate. And oftentimes we don't know that in the beginning. We might have an idea through the initial fact investigation, but we don't know that. Hopefully at the end, we can give the heirs the money that's theirs, and we would close out the estate, and that would representing the end of the probate process and the conclusion of that probate. If you'd like to learn more about the probate process, give us a call. We're happy to talk to you about it, and we're happy to help you through this very difficult process and make it a little bit less difficult and a little less responsibility on you by taking the responsibility and taking care of it for you. I say to all my clients, if you're patient, I'll be persistent. Call us today.